So the idea, I had the idea early this year, no, last year when we met in Solomon Islands with President Narakobi and David Gono. And I said, look guys, PNG is looking for the big celebrations coming up next year. But there is nothing greater, nothing bigger, nothing more substantive than something that should talk about where we're going. Something that calls for a more critical conversation. All the fireworks, all the jet planes, all the kundu drums, they make empty noises. We will be going nowhere. So with that rather impetus at the heart, I speak to those two gentlemen and they said, yeah, I think a constitutional conference, a national constitutional conference would be a great idea. So I did a concept note, went to some agencies, there was a bit of reluctance, but lo and behold, visionary leadership at CLRC took it on board. So thank you. Please, CLRC team, Secretary Dr. Matui, thank you for your leadership in this. I'm glad to see the idea became reality and some great conversations, right? The last 24 hours, oh, it's beautiful. And we have some great leaders of our time who might not be here for long, you know. So thank you, those that have gone already, but I'd like to recognize our former Chief Justice, Sir Arnold Ahmed, and Ambassador of PNG to the US, and other dignitaries and delegates as well. And I'm happy to just not talk to. You know, I think, so Timer, you may be strict on me. Now, I have presented this at, the Chief Justice, Sir Gibbs Salika, invited me to speak to the judges earlier this year on this topic. You will find the full lecture recorded at the PNG Judicial Excellence website. It is there. If you've been there, it's about 30 minutes or 45 minutes lecture. I will scale down to about 8 minutes. So please go and look up there. Another thing is, this is derived from my book, which is outside. It is finished from yesterday, but you can sign up. There's a sign up list if you want to order it. So I've got two sources where you can get this speech. So that's why I'll just quickly run to the critical points. Rethinking judicial power in PNG, judicial leadership. I also add rethinking separation of powers doctrine. At this time, and I'd like to bring in some of the comments from this morning and yesterday, but I'm very mindful, but I hope that you will join that thread of how they all weave in together as I speak to this. We've been talking about reset, rethinking, reimagining. This is part of that conversation. Now, judiciary is a pillar, is a fundamental pillar of the Constitution. But in PNG, and obviously part of the traditional separation of powers doctrine, and I say traditional intentionally, because I think there is a modern contemporary notion of it too. But judiciary is an indispensable part of our national story. But more than that, the judiciary in PNG has become the most trusted institution, despite its shortcomings when compared to all the other arms of government. Justice Devani once described it as the last bastion of hope in a sea of uncertainty. Belden Amar and other political leaders, Luther Wenger, the phrase true character is intentional because it asks us to differentiate from the false character, the superimposed, the inherited assumptions, the law school indoctrinations. That you were told that Montesquieu thinks that way, you must follow. John Locke thinks that way, you must follow. William Blackstone thinks that way, and that's why you must follow. It asks us to go back to the true character, the PNG idea of it, the homegrown idea of it. The same thing applies to separation of powers doctrine. Montesquieu said 3 arms, but do we really have 3 arms? Or we just say 3 arms because that's what we've been told, and then we practice, and it becomes part of our system, part of our DNA, and we just accept it. Section 99, yes, it says the 3 arms, but it says in principle. It didn't say it's cemented. It's very different to Australian constitution, where the 3 arms of government is clearly laid out in the 3 chapters. It doesn't say in principle. In PNG, it put a caveat in section 99. It's only in principle. What does the homegrown notion of separation of power is? Homegrown definition of a judicial character. To do that, you will have to take the historical part to see the legitimate basis of the Constitution. PNG conducted 600 meetings and 3,000 submissions, spanning over 5 or so years with 3 different constitutional committees, going to 13 different countries across the world. It is the most exhaustive consultative constitution in the history of the world. No other country has come close to this time. You can be proud of that. Australia, for instance, conducted only 3 consultations. There you go. John Momus said, 2019, we attempt to make every villager a stakeholder in the Constitution. Judge Canning, in the 1976 case, said that was an attempt to tap the will and spirit of the people. And so out of that, you have the most popular, sovereign-led, legitimate constitution ever drafted. Because if people are the source of power, everyone was involved. At least the effort was to that extent. So what do these people say then to the Constitution? The CPC even say this. They say, we will not draft our Constitution, and I cite from the prefabricated ideas of Canberra. Prefabricated ideas of Canberra. Or let our Constitution to be drafted in Marlborough House in London, which at the time is the bed center of all colonial constitution. Or go to Paris, where all the other French colonies and British colonies have gone. They say, we will do it from our own people. And with that mission, they conducted the historic consultative process. So out of that, they come up with something, a lot of significant things. Time hasn't alluded, but please see my book. But 2 things which I was alluding to. First, the character of the judiciary. They departed from the Australian or Anglo-British, Anglo-Australian conception of judiciary as a passive actor who stands by and let lawyers come to them. And then they come in and they decide. If no lawyers come to them, they stand by. That's what Australian judges are doing. But the CPC said, no, we've got to depart from that. We want our judges to be infused into the system, to become stakeholders actively involved in the construction of the PNG society. Their judicial power and everyday exercise of it must be considerate of all the circumstances of the country, socio-political, economic, not only restricted to the legal black letter law analysis. Something I describe as a transformative function of the judiciary. Now, they didn't say only just by the words of it. They went further, and there are 12 provisions in the Constitution that entrench that idea. But even before that, they declare the judges to be leaders, not just judges, instruments of the justice system. All the other judges in the Pacific, Australia, New Zealand, they are seen as instruments of the justice system. Whereas PNG, the CPC, was very intentional. And I was glad Dr. Momes in his passing comments said that Ratu Mara taught the national goals and directive principles were strange. You see, those were challenges that they faced, but the CPC believed in the ingenuity, in the innovative mind that they have before them. The course from the consultation, they had a special mission. The Fijians didn't have such a broad consultation to realize the importance of the national goals and directive principles. So while they define judges as just judges, PNG defined them as leaders. That's why you have the leadership code. They are part of that. Now, what does the leader mean in a Melanesian society? You've got to take the contextual interpretation like Judge Virgin Arakobi told us this morning. What does a leader mean? In a Melanesian society, leader means an all-encompassing function of a person to which everyone looked upon for guidance and direction and solution. Not to be secluded in their bents, away from the society, bystanderism, as some scholars have called it. Just on the side, waiting for courts to come. They have to be part of the creation, development of the society. So there are 12 functions that consolidate that. I will only touch 2 of them quickly. Time is catching up. Section 57. There's a presentation coming up. Go to that presentation. The voluntary powers of the court to enforce human rights. No other constitution in this region have it. Australia, New Zealand. If it was in Australia, it would be a constitutional crisis. And I'm a student of Australian constitutional law. I teach the thing as well at the university down there. They couldn't believe it. The professors at ANU couldn't believe it. Australian National University couldn't believe that we have a section 57, where judges can just pick up a phone or summon the police minister. Why is it that this is happening? You cannot go there. There will be constitutional crisis. Our thinkers say we have to depart. Give judges their power. Section 23. Supreme Court judge can summon the speaker to convey sitting. And they have done that last year. Society is going to break down. You are attacking parliamentary supremacy, they will say, in other countries. In PNG, we wave it with such pride. So what does that mean for our judges? For our judiciary? They're not the black letter law judiciary. They are transformative. Time's catching up. I'll leave the other 10 functions for you to have a read. Now, Judge William Prentice in 1976 looks at all those 12 functions and say, PNG judiciary is crazy. He used the word frightening. I will skip that part. Now I'll go to the separation of powers doctrine and I'll finish. So what does all of that mean? The innovation of the CPC didn't only stop there with the judiciary. They went a bit further. Because they tailor-made the function of the judiciary, they also tailor-made, in my interpretation, the whole doctrine of separation of power. Because they created something else. 32 independent constitutional bodies, CLRC, Ombudsman, Public Prosecutor, with a clear mandate that those institutions are not subject to any authority. That's clearly spelled out in no uncertain terms. Which simply means that they do not fall under any 3 arms of government. They live, breathe, and give birth to outside of that framework. Because no other constitution in this region, in the Commonwealth, have something of that nature where bodies live outside of it. Australia attempted it in 1903. By 1933, the High Court ruled it as unconstitutional because they said what? It was the 4th arm, which is not what we wanted. But the CPC took it on board. So these 32 bodies, they live outside of the 3 arms of government. Now, where do we place them? We can say 3 arms of government all we want, and then you turn around and you look at these 32 bodies and you say, so where do you guys fit in? You've got to include them. So to me, they are the fourth arm. They are what I described in my book as a quadripartite model of separation of power, the fourth arm. CPC envisaged to move from the tripartite, three arms of government, to the fourth quadripartite. Now, if we elevate them, if we give the recognition and respect that they deserve, yesterday and today about the constitutional bodies not getting the support, you won't have that complaint. Because we will all recognize that they are elevated to the fourth arm. And they also need to be on that platform of a recognized arm of government, therefore getting the resources and the support. If you forget all of that, just linger on this point. Three arms of government, but what happened to the 32 other bodies? Are they bastards? Just finding their way around? Then, so the separation of powers doctrine, the constitutional story is not finished. We haven't fully appreciated the innovative framework in our Constitution. Next time, when we think about Section 99, think about the 332 bodies that are bastardized in it. So, are we a quadripartite system? That's my challenge to you. My book argues that yes, we are. My book argues that the judiciary is a transformative function. And I'd love to leave that with you. In your profession, in your lawyering, in your judicial work or any other work, think about it. Someone challenged us yesterday, I think John did in his book. He said, we're not just here to loud-hailer the Australian or the New Zealand or the British systems. Let's look deep within and unveil, find the reality of who we are. This is part of the story. Identify that the CPC created one of the most unique constitutional framework. And it is incumbent upon us to advance it. And do so without fear or favor. And do so even if it means unsettling the Australian counterparts, the British counterpart, because that's what CPC started when they say, we will not draft a constitution based on the prefabricated ideas of Canberra or in Marlborougugh House in London or in Paris. Thank you.